have Fierce Ayo Tavers, Youth Rep Stephanie Jean-Jacques. We have Night Crew, we have Goso, Shaquila Santiago and Anna Com, and Cases and CJA who are here as well. So today we want to make sure that we're giving some information to folks, helping dispel the myths about what's happening with the bail reform that people are trying to bring back. And I know a lot of folks are trying to use fear and misinformation about it. And so we're here today just to break some of that down. And for those who don't know, bail is really just meant to make sure people will return to court. That's it. That's all the purpose was supposed to be. But for too long it was being used to hold people in jail, not because of anything else besides them not being able to afford the ability to pay. And so that's what some of what we're going to talk about today. Today we're joined by CCI, Crystal Rodriguez, Bronx Defender Scott Levy, Bronx Freedom Eleanor Weissman, and Bronx Community Solutions Maria Almonte.
Thank you very much, Public Advocate. Maria Almonte Weston, Bronx Community Solutions. I am the Project Director for Bronx Community Solutions. And along with providing supervised release, which is pretrial diversion services, we also do a lot of work in the courthouse with individuals who have to actually do alternatives to incarceration. I am a social worker, and a lot of the services that we provide is in the court.
Hi, my name is Scott Levy. I am Chief Policy Counsel at the Bronx Defenders. We are one of two public defenders in the Bronx.
Hi, I'm Crystal Rodriguez at the Center for Court Innovation, and there I'm the Deputy Director of Jail Reform, and a lot of what I do involves a lot of policy and planning and thinking through how best to reduce the jail population in New York City. And most recently, in light of the bail reform, a lot of my work has been around thinking through things like the supervised release program, which Maria oversees here in the Bronx.
Hi everyone, my name is Elena Weissman. I'm the director of the Bronx Freedom Fund. We're a community bail fund, and from 2007 till December 31st, 2019, we paid bail for people who can't afford it in the Bronx and more recently in Queens.
All right, thank you. So first we just want to ask, why was the fight for bail reform legislation so important to your organization? What drove you to fight for those reforms? So anyone can answer.
Well, thank you. So, as a public defender, every year we represent, these days, about 22,000 people a year in the Bronx courts. And what we know as public defenders, and what we know is just working with the community that we work with, is that pretrial incarceration, right? People who are sitting in jail, not convicted of anything, presumed innocent, that being detained pretrial is the single most important fact and thing that determines the outcome of a criminal case. We know that people who are detained pretrial are more likely to plead guilty. They're more likely to plead guilty to higher charges. They're more likely to get sentenced to jail time or prison time, and they're more likely to get sentenced to longer sentences in jail and prison. And we also know, of course, the conditions on Rikers Island and the boat, right? What people have to live through when they are on the island, and when they are away from their families, their communities, their support networks, healthcare and childcare. And so for, as long as we've been in existence, we have seen really the destruction that comes along with pretrial incarceration, the way that it tears families apart, right? The way that it makes it impossible for people to keep jobs, the way it leads to deportation, and the way that it really just really can tear families and communities apart. And so for years we've been trying to get people out of pretrial detention, and also to really focus on what it is that's keeping people in jail. So we've been working really hard, and we were very much involved in the bail reform movement over the last few years, and we're really encouraged and thrilled with the passage of the bail reform law that was passed last spring in Albany and implemented on January 1st. I don't want to go on and on, but what I really want to say is that what we have seen from our clients and their families is that despite what you sort of see and hear in a lot of the press about bail reform, that bail reform is really working. In the Bronx and really across the state of New York, tens of thousands of people since January 1st have gone home to their families. They've lived their lives, they've woken up in their own beds, they've gone to their jobs, they've taken care of their kids, right? These are not stories that make it on the front page of the papers, right? Man wakes up in in his own bed is not something that you would see on the front page of the New York Post, but it is the reality and is the truth for tens of thousands of people across New York State. And it is really transformative, right? It has changed the way that the system thinks about pretrial detention. It's changed the way that the system thinks about liberty and whether people who have not been convicted of anything, people who are presumed innocent in our system, are treated and are allowed to be out, to fight their cases, to assist in their defense, and to really live their lives during the pendency of their case. So we really have seen, we've seen the destruction that pretrial detention that results from pretrial detention, and we have seen since January 1st the success of bail reform, and really believe that it is working, and sort of seeing it in countless ways play out in the lives of our clients and their families.
All of that, thanks, Scott. I think from our perspective, we were created in order to put ourselves out of business, right? Like bailing people out with a rotating pool of money was intended to be this short-term tool to prove that people can be free pending trial and they come back to court, because as a public advocate reminded us, that's the purpose of bail. It's not supposed to keep people in jail. It's supposed to be an instrument for liberty, a form of collateral that you get back at the end of your case. And so from what we've collected a lot of data and stories and stood by our clients as they live all of this out over the last decade or so. We've seen 95% of our clients come back for all of their court dates, 85% of them not convicted of a crime. And so for us, we don't want to just kind of like harp on that point forever. We wanted the system to adjust and to allow people to have those case outcomes, to return to court and to return to their normal lives on its own. And so we're really thrilled to see this come about so that this can be a right for everyone and not just a privilege for either those who are wealthy enough to buy their own freedom or for people that like we happen to interact with as a bail fund, because we are supposed to be a short-term Band-Aid, not a leg of the system.
We've heard from the opposition of bail reform that judges no longer have the ability to make a determination that they feel is best. So can you talk about what discretion judges had and what discretions judges still have now?
So prior to bail reform, the way the criminal justice system in New York City and New York State would work is that folks would come before the court within 24 hours of arrest, ideally, sometimes longer, but that's the mandate, that it'd be within 24 hours. And the judge would try to make an assessment with maybe 2 to 3 minutes time about whether or not this person is a risk of failure to appear, meaning they're not going to show up to court, or if they're more likely to make their court appearances. And that was information that was a decision they made based on information provided in a pretty relatively short amount of time from the prosecutors and the defense attorneys, and they would make that assessment. Their choices for most of the state up until the statute were release on their own recognizance or set monetary bail. Those were the predominant choices that the judges had. Part of what the statute does is that it creates other mechanisms, other ways to incentivize, encourage, or support people to come back to court other than detention, right? So it helps to sort of reduce the reliance on jail as the sole option, and it creates things like supervision and monitoring by pretrial service agency. So, and Maria would actually be able to speak more to this, but the supervised release program that's been functioning in New York City here in 2016 is sort of steps into that pretrial service role. But the way the legislature wrote out the statute is that there'd be some agency run by the county that would connect with people and make sure that they were on track in terms of their court date. The statute also introduces this idea of electronic monitoring, something that hasn't come into effect, but it's something that is anticipated or at least was part of the intention in the statute to create this other option for judges to consider. So in some ways, the judges, in terms of their discretion or decision making, is in some ways it's limited in that you can't use money bail for all charges. You can use them for some of the more the charges that are considered to be violent. You can still use bail. But in other ways, it allows them to make a richer decision, right? They have more options. They're not choosing between just two essential options.
So while the new legislation might have not afforded maybe judges to have those very strict choices, one of the things that it has allowed when we do supervised release, as all supervised release programs do, is because we have clinicians on staff, because we have case managers on staff, we get an opportunity to then do a much more in-depth, thorough assessment with an individual and then offer them voluntary services so that it's on them what they're willing to do in terms of wraparound services that has nothing to do with them being able to come back to court to fight their case. And the majority of individuals, even if they might have a high need for services, they want to have the option and the choice to decide what is it that they're going to be able to do. And our voluntary referrals are a big testament of the fact that when we engage people in that way, we get actually better results.
What we saw before bail reform was that judges actually had a fair bit of discretion. They just never used it, right? Because they had this one tool that everybody defaulted to, which was to set money bail and then to forget that those people existed, right? They would make that decision and then they would move on to the next case. And I think what the new law really does is force judges to actually exercise discretion in a way that they've never done before, right? So I think one of the things that you hear a lot in the press about bail reform is that it has taken away discretion, sort of as Crystal said. But I actually think what it has done is required judges to exercise discretion in a much more thoughtful way, utilizing Bronx Community Solutions, right? Making sure that people have options, making sure that the root causes that lead people into the criminal legal system in the first place, that we're actually addressing those things rather than throwing pretrial incarceration at a problem, and then, which really what we know is that pretrial incarceration not only doesn't fix those problems, it makes things worse, right? Spending just a few days in jail makes somebody more likely to end up back in the criminal legal system, and we are now, I think, recognizing that we can ask the system to exercise discretion that is supportive and that is productive, not just for our clients, but really for everybody in the community.
One of the other things we keep hearing is that the courts are letting dangerous people out of jail. We also keep hearing that these reforms are allowing repeat offenders to offend, and they keep going in and keep letting out. I heard one story today about someone who's been breaking some things in cars, keep getting arrested, they keep letting them out, and the police are blaming the bail reform. So can any of you address any of those two concerns that people are probably hearing over and over again?
One of the things I think is a common misconception about pretrial justice and bail and the bail system generally, and that we sort of started this panel with, which is that the bail system and the pretrial justice system were really designed to get people to come back to court, right? We have a presumption of innocence, which means you're innocent until proven guilty in our system. And so people really, our Constitution says that people should be at liberty until they're convicted, right? So that is sort of a constitutional principle that our system operates on. But what we also know is that the system, pretrial incarceration and bail, is actually really not an effective tool for achieving sort of these public safety outcomes that you're hearing about. And so what we hear about in all of these cases that make it into the press, what you find is when you look at them, they're often about deep, untreated mental health issues, deep, untreated substance abuse issues, and these are people who are not actually spending years of their life in prison, ultimately, right? These are not cases that result in long prison sentences or long jail sentences. And so, so calling for pretrial detention in these cases is asking to put them in jail for a short period of time, which we know will exacerbate the problems that were leading them into the system in the first place. The other thing that I want to say is what we're also hearing for are calls to allow judges to consider dangerousness, right? This is a thing that we hear over and over again. But when you actually look at the data nationwide, what we know is that an exceedingly small number of people who are released pre-trial actually commit serious violent felonies when they're out, right? It is, in fact, of all people who are released pre-trial, most studies show that it's less than 2% of people who actually go on to commit some sort of violent offense. And what we know is that even among people who are deemed quote-unquote high risk, right, in places outside of New York that use risk assessment tools like algorithms that try to predict these types of things, the most commonly used algorithm that is used that labels people high risk people have less than a 10% chance of being rearrested for a violent offense. In fact, it's about 8.6%. So even among the small sliver of people who algorithms tell us are high risk, 92% of those people do not go on to be rearrested for a violent felony offense, right? So the system is actually really bad at predicting future behavior. In fact, we can't do it, right? And I think if you think about it, it's sort of intuitive, right? It's really impossible to predict what a human being is going to do. But what we know works is support systems, right? We know that having people in community with the people who care about them and watch over them, and with the access to supports and access to services and access to things that actually will allow folks to be healthy and live the lives they want to live, that is actually what is really effective at keeping people out of the system. And so, again, the press is really good at finding those cases, right, that are sort of the outliers. But what we see day in, day out is that people are being released, they're living their lives, they're getting the help that they need, and the sky is not falling, right? In fact, in the Bronx, we were talking about this earlier, bail reform didn't change the culture in the Bronx all that much. The Bronx already had a culture of releasing people and getting them supports and services, and it has worked in the Bronx for quite a while. And so I think the calls for dangerousness and the calls to allow judges to start doing that not only is not effective, the final thing I will say on this, and I will put the mic down, is that it is also sort of an invitation for implicit bias, right? We know that overwhelmingly the people who will be deemed dangerous are overwhelmingly men of color, right? That is shown to be true everywhere. That allows judges to try to make these determinations, and that, again, young men of color will overwhelmingly be deemed high risk, even though they would not have been rearrested, and that the burden of dangerousness falls overwhelmingly, disproportionately on people of color, men of color in particular.
I want to add, I guess, two things in addition to like this culture of our existing in the Bronx, maybe with the Bronx leading the way, but New York City generally also has a culture of releasing people on their own recognizance, right? So even pre-bail reform, about 85% of folks who came before a judge after an arrest were ROR'd, no conditions, just released on their own recognizance. Of those folks, 85% of them came back to court, and then of the folks who maybe missed a court date, within 30 days of that missed court date, they returned to court. And so we know from those of us who have worked around the criminal justice system, prior to joining the Center for Court Innovation, I was a public defender in Brooklyn, right? So I got a lot of firsthand view of the way people go through the system. And one thing that you learn is that folks most often don't miss court because they're just trying to abscond, flee, avoid their obligation to the court. They sometimes miss court because they couldn't arrange for childcare. They sometimes miss court because they work jobs where they just can't ask for a day off and get paid for that. They just don't have those basic conveniences that many of us maybe don't realize aren't available to everyone, right? So I just wanted to something that we might all know just from our common sense living is that often, very often, when we talk about dangerousness and public safety, we're thinking about who are we protecting, right? Who are we making safe? And what we know is that oftentimes the person who is the defendant today is the victim tomorrow. And the person who is the victim today is the defendant tomorrow, because our criminal justice system is cyclical in that way. And I haven't really heard a lot of the conversation around that when we're talking about dangerousness and public safety.
Conversation about some of the charges that are now available with cash and some that aren't. So a lot of people have talked about we've ended cash bail. Well, we really haven't. We've reduced cash bail. So can someone talk a little bit about which crimes are still cash bailable and which are not?
I'm going to make this relatively quick. For basically, misdemeanors and nonviolent felonies are no longer eligible for money bail, with some very important exceptions. And violent felonies, with a few exceptions, are eligible for money bail, for cash bail. So the exceptions to the of misdemeanors and nonviolent felonies, all sex offenses remain bail eligible. Violations of orders of protection in domestic violence cases are also bail eligible. There are some other charges that remain bail eligible. One other thing that I think is very underreported and not particularly well understood by the press is that somebody who has been released on a felony and who is rearrested on a felony, regardless of whether it was a violent felony or not, becomes eligible for bail. People who are willful and persistent, who willfully and persistently miss court, regardless of what they're charged with, become eligible for bail. And so there are actually these categories built into the law to account for a lot of the sort of situations that people often bring up. Violent felonies remain detention eligible and bail eligible, and misdemeanors and nonviolent felonies, again with some very important exceptions, are not eligible.
Expanding on our conversation about bail reform, what other reforms should be on our radar now that we've seen some of the gaps in our city's ability to provide resources? What other resources should we really be focused on as opposed to trying to revert back to where we were? And is it Elena? We'll start with you, so I'll bring you in the conversation a little bit.
So I think, bail and the cash bail system and the need for bail reform is not the root problem here. It's a symptom of a larger problem, which is about racism and classism and the criminalization of poverty. And so I think there's, especially on that last point, a lot of reforms that are being spoken about right now that would make a big difference. So like decriminalizing certain offenses that have a lot more to do with being poor and a lot less to do with being violent or bad or a criminal or whatever you want to call it. I also think within the criminal legal system, there's people who are in solitary confinement for a really long periods of time that the UN calls torture. So there's a big push to change that right now. There's a lot more to do, but I also think that this is an invitation for all of us to reckon with what got us here in the first place, and that is those three things I mentioned before, I think. Racism, classism, and the criminalization of poverty.
When it comes to the criminalization of individuals who are either addicted to a substance or in a high risk of overdosing from a fatal opioid, looking at that from a public health perspective and from a harm reduction perspective and really pushing the needle to that is a place where I think where we want to go. Along with supervised release, Bronx Community Solutions also partners with NYPD and the DA to do Bronx Hope, which is HOPE is an acronym for Heroin Overdose and Prevention Education. And what's unique about it is that I'm really convinced that when somebody gets arrested, that's a crisis situation. That's an opportunity to really try and find a way to connect them immediately to services. So someone who gets arrested in the Bronx for controlled substance at the precinct, a peer advocate should be immediately dispatched to connect with that individual. That's what we do in the Bronx. But if we think about that for other types of charges that we can do the same thing too, I think that that's a place that I think that we could really have a great outcome for.
Who determines what constitutes a violent offense? For example, Khalif Browder was charged with a violent crime for an alleged robbery of a backpack. Would new legislation be proposed to determine violent offense?
So in terms of who determines what a violent offense is, so our statute, our penal law, like New York State law, has actually a list of charges that are categorized as violent. So when we say violent felonies mostly remain bail eligible, we're talking about that specific list of charges. In the example that the question raises of Khalif Browder, that at that time he was charged with what is still considered to be a violent felony offense. So when we think about violent felony offenses, we're talking about like assault where serious physical injury occurs. We're talking about certain degrees of like sexual abuse. We're talking about rape, kidnap, murder, all the things that I think clearly stand out as violent.
Does the 650,000 stop and frisk arrests that was part of the Bloomberg administration lead to a large amount of bail cases today? So not all of the stops led to arrests. There were actually more than $650,000 in 1 year. But I guess the question is, maybe what did the impact of the large-scale abuses of stop and frisk during the Blueberg era, did they have any impact on what we're talking about now?
So I think, I mean, we could spend all night talking about how stop and frisk and the NYPD's use of stop and frisk has brought us to the point where we are, and how it continues to, I think, impact not just the criminal legal system, but entire communities across the city. I will tell you that as my personal mission has been trying to get researchers to study what the economic and social cost of stop and frisk is on an entire generation of people and communities, because we know that certain communities were much harder hit than others, and I don't think we fully understand the impact of that policy. What I will say about its relationship to bail is that what we saw for years is that people were being arrested, tens of thousands, hundreds of thousands of people across the city being arrested for very low-level offenses. Because people were being arrested oftentimes repeatedly, we were seeing people charged with very low-level offenses spending 3 days on Rikers, 5 days on Rikers, a week on Rikers, right? And we know just how destructive those short stays on Rikers can really be. Even before bail reform, though, I think there has been a shift in that mentality. There's been an effort to try to, right, we saw a reduction in stop and frisk, not nearly as much as any of us, or I won't say any of us, I would like to see. We saw a significant reduction in stop and frisk, and then the number of arrests for low-level offenses has come steadily down since the height or low point of stop and frisk in 2011. But what I think folks in the system really learned is, one, sending folks to jail for a few days is counterproductive and destructive.